2 on January 28th, 2022, and today's proceedings before the Board of Disciplinary Appeals are called to order. In furtherance of the Supreme Court of Texas's emergency orders regarding COVID-19 and consistent with Part 7 of the Texas Rules of Disciplinary Procedure, the Board of Disciplinary Appeals will hear today's cases through remote connection. If you get disconnected, please know that we will pause the proceedings to allow you to regain connection. If you have any technical difficulties, the BODA staff can be reached by phone, and we will post that number in the chat. So take note of that in case you need it and have any technical problems. We ask all the parties present to conduct themselves as if they were present in person in the Texas Supreme Court courtroom. I'll begin by introducing the board, and I'll ask that each board member raise a hand as introduced. I'm Kelly Henson from Dallas, and I'm chair of the board. Mike Gross from San Antonio is vice chair. The other board members are Jessica Barger from Houston, Jason Boatwright from Dallas, Guy Choate, San Angelo, Joe Cleveland from Fort Worth, W.C. Kirkendall from Seguin, Rudy Mateer, Pflugerville, Bill Ogden from Houston, Nancy Stone from Amarillo, Cindy Tisdale from Granbury, and David Iglesias from Tyler. 6 members constitute a quorum of the board, and as you can see, a quorum is present today. The board instructed parties and counsel to submit electronic files in advance of the hearing today. If you intend to offer those exhibits, they must be offered into evidence. Simply submitting them in advance of the hearing is not sufficient. They must be submitted and admitted by the chair in order to be considered evidence and made a part of the record. If you want to offer an exhibit that was not submitted in advance, you may request leave to do so, and you can use your screen sharing feature to display those exhibits. Mr. Krueger, are you going to call any witnesses besides yourself this morning?
I am not.
Okay, so no need to invoke the rule. Commission, do you have any witnesses?
We do not.
Okay. Any pro se parties wishing to present testimony need to be sworn in as a witness and subject to cross-examination. We have a court reporter this morning, Ms. Siebert, and she will be recording today's proceedings, and we'll make a copy of the proceedings for posting for our website. Any other recording is prohibited. All right, let's call this morning's docket. I'll note for the record that the following cases have been removed from our docket today. Case number 65862, In re John O'Neill Green, a compulsory discipline matter, has been removed from today's docket in response to the commission's request. Case number 65865, In re Wesley Lyndon Clark, a reciprocal discipline matter, has been continued to the board's en banc hearings on April 29, 2022. Case number 65866, In re Alfonso Kennard Jr., a reciprocal discipline matter, has been continued to the board's en banc hearings in April. Case number 66219, In re Derek Alfonso Quinada, a revocation of probation matter, has been removed from today's docket in response to the commission's request. The first case remaining on today's docket is case number 65866 in the matter of David Allen Krueger, which is a reciprocal discipline case. Is the commission ready, Ms. DeBerry?
We are.
What is your time estimate this morning?
For Mr. Krueger, 5 minutes.
Mr. Krueger, are you ready to proceed this morning?
Yes, sir. Yes.
What is your time estimate?
10 minutes.
All right. The second case on our docket today is case number 66185, in the matter of James Robert Mason, which is a reciprocal discipline case. Ms. DeBerry, is the commission ready on Mr. Mason?
We are.
Do you have any time estimate?
5 minutes or less.
Is anyone present representing Mr. Mason? We have not received any response from Mr. Mason as far as I know. Ms. DeBerry, have you heard from Mr. Mason?
We have not. He's filed no pleadings to my knowledge either.
Ms. Truitt, has Mr. Mason attempted to contact Boda to your knowledge?
No, ma'am.
And I take it he's not in the waiting room?
No, he's not.
Okay. That completes this morning's docket call then. We will call the Krueger case first, and then we will handle Mr. Mason.
Ready for me to proceed?
Let me just call the case real quick, and then you can start.
Okay.
We'll call case number 65866 in the matter of David Allen Krueger. Council, as you know, Mr. Berry, for the compulsory discipline matters, we ask that you address proof of service, proof of finality, the conclusion that the conviction is an intentional crime, and the appropriate discipline that you're seeking in the case. Would council please state their appearances for the record?
Judith DeBerry for the Commission for Lawyer Discipline.
Thank you.
David Krueger. Oh, David Krueger, pro se.
Thank you. Ms. DeBerry, you may proceed.
Thank you. May it please the board. This is a compulsory discipline case brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the respondent's conviction for wire fraud. We filed our petition for compulsory discipline on September the 9th, 2021. Respondent was personally served with the petition and notice of hearing on September the 15th, 2021 by Renee Kendrick, Deputy Sheriff with the Canadian County Sheriff's Office. Proof of service has been on file since October the 5th, 2021. Mr. Krueger filed a motion for continuance, which was granted, and the boards reset the hearing for today. On August the 21st, 2019, in cause number 519 CR 18 RWS-CMC styled United States of America versus David A. Krueger Jr., the United States District Court for the Eastern District of Texas, Texarkana Division. Respondent was charged by indictment with count 1 wire fraud in violation of 18 United States Code Section 1343. On January 5th, 2021, a plea agreement was entered in the same case wherein the respondent pled guilty to count 1 of the indictment.
Objection.
What is your objection?
That plea agreement, the relevance of that plea agreement, it was never accepted by the court. It was voluntarily withdrawn, and it was never made part of the sentencing.
Ms. DeBerry, your response?
I did not see that it was drawn, but there was an amended judgment that was entered on, and if I can continue, I can do the rest of it.
The objection's overruled.
On May 13th, 2021, an amended judgment in a criminal case was entered wherein the respondent pled guilty to count 1 of the indictment and was committed to the custody of the Federal Bureau of Prisons to be imprisoned for a total term of 18 months. Respondent received credit for time served on October 3rd, 2019. Upon release from imprisonment, respondent will be on supervised release for 3 years. Respondent was further ordered special conditions of supervision, which included that he must provide the probation officer with access to any requested financial information for the purpose of monitoring restitution payments and sources of income, must not incur new credit charges or open additional lines of credit without approval of the probation officer unless payment of any financial obligation ordered by the court had been paid in full, and must not serve as an attorney or engage in the practice of law in any capacity. Respondent was further ordered to pay penalties of an assessment in the amount of $100 and restitution in the amount of $350,000. At this time, I'd like to offer the following exhibits. Exhibit 1 is a certified copy of the indictment dated August the 21st, 2019, in cause number 519-CR-18 RWS CMC styled United States of America versus David A. Krueger. Exhibit 2 is a certified copy of the plea agreement dated January 5th, 2021 in the same criminal case. Exhibit 3 is a certified.
Objection to item 2 being admitted on relevance, the same objection.
We'll handle all the objections after she lists them, and I'll come back to that.
Okay, thank you. I don't know quite the procedure on some of this, okay?
No,
Thank you.
that's perfectly understood. Thank you.
Exhibit 3 is a certified copy of the judgment in a criminal case dated May 13th, 2021. Exhibit 4 is a certified copy of the amended judgment in a criminal case dated May 13th, 2021 in the underlying criminal case. Exhibit 5 is my original affidavit attesting to the fact that respondent is the same person as the person identified as the defendant in the underlying criminal case. Exhibit 6 is the original certificate of Blake A. Hawthorne, clerk of the Supreme Court, dated January the 18th, 2022, indicating that respondent is licensed but not currently authorized to practice law in Texas due to a disciplinary suspension. And Exhibit 7 are certified copies of respondent's disciplinary history. At this time, I'd ask that the exhibits be admitted.
Mr. Krueger, I understand you have an objection to Exhibit 2. Do you have any other objections?
I do. I object to pages 10 through 21 of Exhibit 7 of the prior discipline. And my objection is based on relevance and prejudicial. The state bar is attempting to disbar me for the May 21 criminal judgment. And the indictment in the May 21 criminal judgment involved a single count of wire fraud for funds from one single client, Chad Kilcrease. The Kilcrease matter is the subject of the July 6, 2017 grievance lawsuit agreed judgment, which are pages 1 through 9 of Exhibit 7s. And I do not object to that. I stipulate to that being admitted. However, pages 10 through 14 is the November 17, 2016 agreed judgment on a grievance matter involving my ex-father-in-law, which has nothing to do with Mr. Kilcrease or the indictment or the criminal judgment of what the state bar is proceeding on this disbarment matter. And therefore, I object for the admission of that as relevance, and also as its probative value is far outweighed by the prejudicial value. Pages 15 through 17 of Exhibit 7 are a October 17, 2016 grievance, an agreed judgment with the state bar involving a client matter from events back in 2008 and 2009, years before I met Mr. Kilcrease, or the matter that they're trying to disbar me for. And therefore, there's nothing in the indictment or the criminal judgment that has anything to do with that previous agreement with the state bar on that disciplinary proceedings. Therefore, I object as to relevance, and I also object as to the prejudicial value is far outweighed by the probative value.
Mr. Berry, would you like to respond to that last objection first with regard to Exhibit 7?
Well, they're public reprimands or hires, so they're in the public domain. As far as relevance, since this is a compulsory case, it's actually based on his criminal conviction, and he served time on that. So that requires disbarment.
So what is your position about whether these prior grievances are relevant to the proceeding here this morning?
I don't know that they are, since it's not a case. I mean, we normally put all the history in. In this case, Mr. Krueger had time that he had to serve, so it's not as relevant as it would be if the board had the discretion to determine whether to suspend him or to disbar him. But I don't believe the board has that discretion in this case.
Okay, thank you. I'll admit pages 1 through 9 of Exhibit 7. And your objections are sustained as to pages 10 through 21 of Exhibit 7. Mr. Krueger, would you like to address Exhibit 2?
Exhibit 2 is, again, the relevance of this. This is a plea agreement that was done during the negotiations up to sentencing. It was signed by by the U.S. attorney and myself. It was at sentencing. It was withdrawn. I voluntarily withdrew it because there were some conditions in there as we got to sentencing that were unacceptable. And the judge even agreed that it needed to be withdrawn. So that was withdrawn. I then opened up to an open plea and an open plea of guilty for sentencing. And then the judge determined the sentence, which was completely different than what was in the plea agreement. So that's the relevance of it. Is why is it relevant in this matter that's about the indictment and the actual criminal conviction and sentencing? A plea agreement that's not part of the sentencing, it's irrelevant. That's my argument.
Okay, thank you. Mr. Berry, what is your response as to Exhibit 2?
I think it's superseded by Exhibit 3, so I have no position on it. It was part of the record. I think all that's really required is the judgment in the criminal case to find, to determine whether or not I'm sorry, I was trying to look at something real quick, to determine whether or not the crime occurred and he was convicted. So I think if the Exhibit 2 is superseded by Exhibit 3 and Exhibit 4.
I object to Exhibit 3 as well.
Okay. With regard to Exhibit 2, your objection is sustained. What is your objection to Exhibit 3?
Actually, Exhibit 3, Mr. Berry is correct that Exhibit 3 is superseded and replaced by Exhibit 4. Exhibit 4 states in the heading that it is replacing Exhibit 3 because of a clerical issue. I looked at the documents and I personally couldn't find any difference, but there must have been some sentence or something that was a clerical issue between 3 and 4. So Exhibit 4 is the correct exhibit to be referencing. Exhibit 3 really should not be in there because it was completely superseded and replaced in its entirety by Exhibit 4. So I object to Exhibit 3.
I think the difference was a date that was misprinted on that one, if I recall, because I did look at that to see what the difference was, and the difference was simply one of the dates had the wrong year or something, if I recall.
So, Mr. Berry, what is your response to his objection to Exhibit 3?
Again, I think all you really need is Exhibit 4. We just put in more of the record. You know, we've even, yeah. So I would say I don't have a problem with it if the board wants to sustain his objection, because what you need is the final judgment, which was Exhibit 4.
Okay, thank you. Objection to Exhibit 3 is sustained. Mr. Krueger, do you have any objections to Exhibit 1?
No, ma'am.
Exhibit 1 is admitted. Do you have any objections to Exhibits 4, 5, or 6?
My objection to Exhibit 6 is just the relevance as to.
Sorry to ask you about.
I'm sorry, I think somebody wasn't on mute. Go ahead.
Okay. Exhibit 6 is just a compliance statement from the state. You don't pay your fees for the bar on a temporary basis, and you the continuing CLE. You don't. You're temporarily out of compliance there. Clearly, those items that happened, 5 to 15 years previously are completely irrelevant. The one item that she did state, which was that she was offering it into evidence for purposes of showing that I don't currently have a license because of this matter, the Kilcrease matter, which is the matter before this court. That's relevant, but all the other items in there are completely irrelevant. So as long as it's limited to the purpose that she stated the use of Exhibit 6, that's fine. Again, it's kind of like Exhibit 7, where there's one sentence that's relevant, And then there's a whole bunch of other stuff that's irrelevant.
Okay, we'll admit exhibit 6, and then we will consider it for the purposes relevant to this proceeding. And we'll admit exhibits 4 and 5. All right, I believe that takes care of all the exhibits, Mr. Berry.
Thank you very much. We respectfully seek an entry of judgment of disbarment.
Thank you. Mr. Krueger, you may proceed, and I'll remind you that this is an evidentiary proceeding, and so if you would like to give testimony, I'll need to swear you in.
Yes, ma'am. Please.
Could you raise your right hand, please? Do you solemnly swear or affirm, under penalty of perjury, that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
So the State Bar of Texas wants to present this case as a typical lawyer felony case. That is, the State Bar of Texas discovers or is notified that an attorney has pled guilty, no contest, or convicted after trial of a criminal matter. Then the State Bar of Texas moves to disbar the attorney pursuant to Rule 805 or Section Part 9 of the Texas Rules of Disciplinary Procedure, and the attorney is disbarred. And if that were the case's fact pattern, I wouldn't be here today challenging the Chief Disciplinary Counsel of the State Bar of Texas. But here is what's different about my case. In December 2015, the State Bar of Texas informs me that they're investigating a grievance against me by a former client, Mr. Kilcrease. I spent approximately 18 months defending myself on the State Bar grievance case, including defending myself in district court filed by the State Bar of Texas, when I refused to admit to guilt in this case. In June 2017, a few months before the State Bar and I go to trial, in June 2017, the State Bar in Texas and I have an 8-hour mediation meeting in Austin, Texas, where at the end of that mediation, the State Bar of Texas and I signed the agreement of the judgment of the partially probated suspension, which is the Exhibit 1 previously admitted. And I'd like that to be duly noted. I'm referring to the Exhibit 1 of the Chief Disciplinary Counsel's previously admitted document, where I agreed to have my license suspended for 2 years from April 2018 through April 2020, followed by a probation of 2 years from April 2020 through April 2022. That exhibit, if I could read the first paragraph of that Exhibit 1 on the agreed judgment, it reads, "On this day came to be heard the above styled and numbered cause, petitioner commissioned for the lawyer discipline, petitioner and respondent David Allen Krueger, respondent, Texas Bar number 240259440, announce that an agreement has been reached on all matters, including the imposition of a partially probated suspension." So I comply with the terms of my 2-year suspension of my license, and I give up my ability to generate income as an attorney starting with April of 2018. 2 years after that agreement is signed between me and the State Bar of Texas, I'm thinking everything is resolved on the Kilcrease matter with the State Bar of Texas, because that's what the agreement specifically states. I'm indicted, I'm served with an indictment, and I'm arrested on a criminal charge on the Kilcrease matter. In November of 2019, and I'd like to introduce Exhibit 3, my Exhibit 3, which is, just a second here, which is the criminal referral of the State Bar of Texas, Robin Landis, to the FBI, dated October, with that referral being dated October 13, 2016. And I'd like to also introduce Exhibit, excuse me, I'll just go through all four exhibits right now, if that's okay. I'm going to introduce them for this section of my testimony. Is that okay?
Yes, that's fine.
Okay. So Exhibit 1, the criminal referral of the State Bar of Texas, Robin Landis, in October 2016. Exhibit 2 is the letter and DVD on my file with the State Bar of Texas that Robin Landis provides to the FBI in November of 2016. Exhibit 3 is the U.S. Attorney's Office from Texarkana letter and the U.S. Attorney's Discovery CD from November 2019. And Exhibit 4 is the U.S. Attorney's Discovery CD from 2019 and the list of the 48 different documents and files that the State Bar of Texas has voluntarily provided to the FBI in my case. I'd like to, I ask that those be admitted into evidence.
The State Bar would object. First, they're not relevant to the criminal conviction, which is the subject of this hearing. And second, that none of them have been authenticated in any way. They're not certified copies. He hasn't brought anybody in from the Federal Bureau of Investigations or anyone else, Department of Justice, to testify as to their authenticity. So we would object.
Mr. Krueger, what is your response?
My response is they're completely relevant to this case. This case is on the matter of the Kilcrease matter, which is the state, which is exactly what this matter is on. Those items are specifically the items that were used in the indictment and the criminal proceedings, and that there's an exception for authentication. You can say whatever. I'm sorry. You know what I'm trying to say. It can be authenticated by a witness that has personal knowledge. I have personal knowledge of those documents. I don't need the state. I don't need somebody to be call a witness from the FBI or submit the Miss Landis from the State Bar of Texas to say that those are her documents. They're in the file that the Chief Disciplinary Office of Counsel has in their possession.
I'll overrule the objections and admit exhibits 1 through 4.
Thank you.
Thank you.
So in November 2019, I received the discovery CD from the U.S. Attorney. And in that discovery CD, for the first time, I realized that the criminal referral was not initiated by Mr. Kilcrease or counsel for Mr. Kilcrease, but that criminal referral was initiated by the State Bar of Texas to the FBI, and that they provided hundreds of documents of my State Bar of Texas disciplinary file, including hundreds of documents of the previous matters of Exhibit 7, which were not relevant, which were not even relevant to this matter, which never became part of the indictment or never became part of the criminal judgment. So my issue really is, I go to mediation. This is 2 years after I reached the agreement. I finally discover that the State Bar of Texas is the one who initiated the criminal proceedings against me. The State Bar of Texas intentionally withheld notifying me of this criminal referral and any documents, one, at any time from the date that they initiated this proceeding in October of 2016, up through the date that we had the mediation and the negotiations I had with the State Bar of Texas on the Kilcrease matter. So for 8 months or so, they never mentioned anything about this. They go to an 8-hour mediation with me. At the mediation meeting, they never mention, we have also initiated this. We know that you've got these criminal proceedings because we actually started these criminal proceedings. They don't mention anything about it. They signed a final agreement telling me everything is completely final. They take no steps to mitigate the bag of, letting the bag that they, the problem that they opened up for me. At no time after the mediation do they tell me about the criminal matters. I only find out about it when I'm in the middle of an indictment in a criminal matter. And as an attorney, you are entitled to the confidentiality of the State Bar of Texas during and after the disciplinary proceedings. At mediation with the State Bar of Texas, I had no knowledge that I was a target of the criminal investigation. But the State Bar of Texas knew that, and there were things that I admitted to and agreed to in that proceedings that had I known that I was in a criminal investigation, again, initiated by the State Bar, I would not have admitted to. I was not given my Fifth Amendment rights, the ability to say, hey, I refuse to answer this, or I refuse to agree to this because of the criminal proceedings. And then it was just turned around and used by the U.S. attorney against me, with the indictment is pretty much word for word what the grievance matter was that was filed by the Kilcrease attorney, and uses language and uses information that was specifically provided to the FBI by the State Bar of Texas that was withheld from me throughout this whole process. So every item in the indictment was included in the grievance filed by Mr. Kilcrease with the State Bar of Texas, or the information that the State Bar of Texas filed in my file that the State Bar of Texas gave to the FBI. There's not a single new item in the criminal judgment that was not part of that grievance of the State Bar of Texas file, or what the State Bar of Texas gave to the FBI. It's not the State Bar of Texas or the Chief Disciplinary Counsel's job to entrap lawyers, to get lawyers to make admissions in confidence and in confidential disciplinary proceedings, because the State Bar decides that they want to withhold the fact that they have initiated a criminal case on the same matters of the disciplinary proceeding. It's not the State Bar of Texas or the Chief Disciplinary Counsel's job to intentionally mislead lawyers in disciplinary proceedings that everything in the disciplinary proceeding, including mediation and negotiations, is part of a confidential process. It's not the State Bar of Texas or the Chief Disciplinary Counsel's job to essentially serve as the discovery and the prosecuting arm of the federal government or the law enforcement agency in a federal case. However, it is the State Bar of Texas and the Chief Disciplinary Counsel's job to be candid, truthful, and fair to an attorney in every step of the disciplinary proceedings. Now that I'm only months away from completing the 4-year sentence that I agreed to, we're in month 45 of 48 of the agreed sentence in June of 2017. The State Bar is trying to punish me again for the same events that they were covered and handled with finality in the 2017 agreement. This is in fact triple jeopardy, because first I'm punished by the State Bar with a 4-year suspension on the Kilcrease matters. Then the second punishment, I'm punished in a criminal action with a judgment and a conviction, and I serve time in a federal prison for the Kilcrease matters, the same matters in the Kilcrease matters. And now for the third time, the State Bar wants to punish me again for the same events through a disbarment. The terms of my criminal judgment already restrict me from the practice of law until January of 2026. I have 18 months of the conviction, of the judgment, and then followed by 3-year suspension. And that was correctly stated in the documents that were entered into exhibit by Chief Disciplinary Counsel. But not practicing law is different than not being licensed to practice law. With a disbarment, I am at the mercy of the State Bar of Texas as to whether or not in the future they ever want to basically allow me to practice law again. Without a disbarment, as soon as I finish the terms of my agreement with in the criminal matter, which again will be January of 2026, this is a long ways off. I will then be able to practice law, be able to generate income, be able to pay the restitution amount that I agreed to pay in the criminal matter. So my main issue with the State Bar of Texas is really one of fairness and accountability. The State Bar of Texas and the Chief Disciplinary Counsel seem to think that they can do whatever they want in a disciplinary proceeding, that they can withhold information from the attorney that in the proceeding, that they can volunteer confidential information of disciplinary proceedings to third parties without any consequences, that they can sign an agreement that states it's all final and all done, everything's done on all these matters, but they don't have to be bound by that finality clause because they can initiate another punishment for the same events and claims covered by the agreement. So if the State Bar wanted to disbar me, they should have proceeded with that disbarment action in June 2017, instead of waiting till now when I'm 45 to 48 months of completing my agreement of the 2017 agreement on the Kilcrease matter. Again, there is nothing new in either the indictment or the criminal judgment that was not in the State Bar of Texas investigations file or the matters that the documents that they turned over to the FBI when they initiated the criminal referral against me in October of 2016. The State Bar of Texas had knowledge of every claim in the indictment, every claim in the criminal is one count of wire fraud. That count of wire fraud was the crux of the grievance in the State Bar of Texas investigation that led up to the agreement, the mediated settlement agreement with me and the State Bar. And the State Bar, since they had knowledge of all that, if they wanted and felt like the right sanction or punishment was disbarment for these actions, they should have pursued it back then, instead of saying, nope, this is the right punishment. And now coming back later and saying, yeah, now we change our mind. We want to ignore that we have an agreement with you. We want to basically try to punish you again and seek disbarment. So that's why I'm here today, to challenge the State Bar disbarment action and just the way that the State Bar has handled this whole matter with me on the Kilcrease matter. Thank you.
Thank you. Mr. Berry, do you want to cross-examine Mr. Krueger?
Yeah, just briefly, Mr. Krueger, before we make final arguments, you had said that you complied with all the terms of the partially probated suspension, but you haven't, have you? You haven't paid the restitution that was ordered in that judgment, have you?
The restitution has been resolved in that matter, yes. So that is an incorrect statement. My response is the restitution has been completely resolved in that matter.
You did not pay the restitution to the two people you were supposed to pay $20,000 to each, did you? I was forced to file bankruptcy because of the actions of the State Bar in pursuing this and other actions. I filed bankruptcy. The State Bar was provided notice, was given as a creditor, entered an appearance in my bankruptcy. The State Bar never challenged that bankruptcy, and so that claim was dismissed in bankruptcy. However, in my criminal action, in the indictment for the wire fraud, the court went through all my bank statements and everything that the State Bar had provided and other things that they had provided, including those $20,000 payments. And they determined— I'm going to object as to relevance at this point and non-responsive.
Well, let him finish his response and then you can object.
Okay, so it is specifically included in the $350,000 restitution amount that I was ordered to pay. So the answer to your question is, did I pay them the $20,000? No. Was that forgiven? No. Is it part of the restitution? Yes.
Okay, you're aware that the bankruptcy code has an exception for fines and penalties for a governmental agency, aren't you? And that those are exempt from bankruptcy discharge?
Yes, we can have it. We can have, and there's an exception to that exception that I qualify for. Do you want me to cite the exception? I can find it in my notes if I need to.
You didn't pay it. That's what I wanted to get at. As far as well, I'll save the rest of it for argument.
Does anyone from the board have questions for Mr. Krueger? Yes, Mr. Kirkendall?
Mr. Krueger, why was the restitution amount so different in the State Bar action and the federal court case?
Because the amounts of monies that I had received from this Mr. Kilcrease involved the $20,000 payments that Mr. Berry mentions, plus additional funds that were put into a business venture, minus $60,000 that I had paid out to Mr. Kilcrease in return of some of those funds. All those items were in the grievance filed in this matter with the State Bar. The $20,000, the $400,000 note, the payments that I paid on these notes. So when the judge looked at what amount does Mr. Krueger owe, he looked at every dollar that Mr. Kilcrease had paid me, including the 20,000 amounts, and every dollar that I had paid him, and came up and said the correct amount that is still owed, including the 20,000, is $350,000.
So you acknowledge that the correct amount owed is $350,000?
Yes, sir. That's what I agreed to, and I've already paid $50,000 of that. and I'm paying $1,500 a month, and I'm current on my monthly payments on that. So I plan to make full restitution to Mr. Kilcrease and live up to what I agreed to and what the sentencing was.
Mr. Krueger, do you have any authority to support the board's discretion to do anything in this case other than order disbarment?
I do not, Your Honor.
Any other questions from the board?
Mr. Krueger, it sounded like you were arguing at a point that as a policy matter, there are circumstances under which the state bar or the CDC should not be permitted to report suspected illegal activity to law enforcement or prosecution authorities. Do you have any cases or rules or statutes that you can cite that would support that proposition?
No, but I would like to reference in response to that Section 5 of, hold on just a second, let me find it here. Part 5 of the Texas Rules of Disciplinary Proceeding, where it specifically speaks as to the duties and rights, duties, obligations of the Chief Disciplinary Counsel. And I'd like to note that as you go through Section 502, there is nothing in there that basically says, that they should be the de facto arm of the prosecution of a criminal action. And in fact, the only place in there where it cites mentions referral is actually in Section H, where it basically says that if the Chief Disciplinary Counsel wants to refer a complaint and information related thereto to any other professional organization or bodies that he or she would deem appropriate for consultation on the nature of the complaint, the events giving rise to the complaint, and the proper manner and resolution of the complaint, the Chief Disciplinary Counsel shall provide the respondent written notice of the referral at the time it is made. That's kind of my big issue. They should have given me notice of the criminal referral. I cannot cite specific case law that says that they cannot participate in an ongoing investigation. The question is, can they initiate? Can they initiate it? Can they withhold the fact that they've made that referral? And I just have to, and then my result is when I find out about it, it's already done through the indictment process. Had I found out about this at the time, I doubt I could have done things to mitigate the indictment. I could have done things to basically avoid the criminal proceeding.
Mr. Krueger, this is Michael Gross from San Antonio. What could you have done to convince the AUSA not to indict you on this case? Had CDC notified you they referred this case to the AUSA?
Well, my attorney would have reached out to the U.S. attorney and basically said, hey, I understand that you've got a criminal matter. Will you be, my client would like to provide documentation prior to the indictment process. He would like to, make his case prior to the indictment process. Once the indictment, I went and talked to several attorneys and they said, look, once the indictment and you're in a federal case, if you want us to fight this, we want a $500,000 retainers up front. You can win this case, but we want a $500,000 retainer up front. The state bar had taken away my license. I didn't have any money to fight this.
Mr. Krueger, my question though, sir, was what would you have done to convince the AUSA that they were not authorized to return an indictment against you?
Well, I would have at least had a conversation that I was denied even having the conversation, denied even the opportunity to present anything. What would I have said to him? I would have said, here's my information. Here's my documents. Before you take this to the grand jury for indictment, this is what I'd like you to consider. Would I have convinced them? I don't know. But I didn't have the opportunity.
In other words, there weren't any legal arguments that you could have made that you were unable to as a result of the CDC not telling you about referring this to the AUSA. You didn't miss out on any legal arguments, did you? In other words, You're not claiming, for instance, double jeopardy or something like that, are you?
Well, my legal argument would be I would have been able to strike various things that were put in that indictment because of no, I go back. I removed that because the indictment. No, I could have, because they were using items that did not have my Fifth Amendment right. They were using items from the mediation and the results of the mediation, those proceedings, as part of the indictment. And I would have had a legal argument to have that stricken or modified from whatever was admitted at the indictment.
So did you file a motion to quash the indictment in the federal case based on those?
Did not.
I'm sorry?
I did not. No.
Why is that?
Because I went to the attorneys I went to, I talked to them about that. I talked to them about changing venue. They basically told me, very expensive. You don't have the money to fight this. And basically you can, I was advised by counsel not to do it. So
you refer to the Texas Rules of Disciplinary Procedure 5.02 regarding duties. Is it your position that 5.02 duties for the CDC, those are the only things they can do? Is that your position? Did I understand you correctly?
No, that is not my position. Clearly, as you read on, it says in any other duties that the commission gives the disciplinary counsel those. So it's a list of duties. But my point was, there's nothing in there that basically says you can initiate criminal referrals. There's stuff in there.
Just so I'm clear, there's nothing that you have to present us today, like Ms. Henson just asked you. There's nothing you have to present us today that says that the CDC is prohibited from referring cases to an AUSA, do you?
That they are prohibited? No.
Okay, thank you, Mr. Krueger.
Any other questions for Mr. Krueger?
Just a quick question, just in terms of chronology. When did the mediation occur with the CDC? Was that before October 2016?
No, it was in June of 2017.
Okay.
So that would be roughly 9 months after the criminal referral. And that's my issue. They knew 9 months earlier that they had started this, yet I'm in mediation with them to settle everything up, and they never mentioned it once.
Any other questions for Mr. Krueger? Does anyone from the board have questions for Mr. Berry?
This is Joe Cleveland. Just a quick question for Mr. Berry. In the proceeding involving the Commission for Lawyer Discipline, where there was a mediation and the agreed judgment in June of 2017, was the CDC at that point seeking a disbarment?
I couldn't answer that. That's not, I can go back and look and see if I can, that was not my case. It was a Dallas case. If I recall, it was at the Dallas regional office. So I don't know if we were. I will say though, that there's nothing in actually Rule 2.16 and 6.08 both allowed the commission to share information with law enforcement agencies. So frequently.
So if the CDC was seeking disbarment, there's this basically a Mother Hubbard clause in this. It says all requested relief not expressly granted herein is expressly denied in the agreement. If the CDC was seeking disbarment, would that mean that they could not seek disbarment after entering into this agreement?
I don't see that as an agreement. That's the basis for that was not the criminal conviction. They did not allege a criminal. One of the rules, let me go back. I've got it pulled up just a minute. the rules that they cited did not include an 804A2, which is a criminal matter. It included, if I recall,
There's a 804A3 that's identified.
that's fraud, deceit, or misrepresentation.
Right, right.
And I think there was some trust account. No. So what it was a communication issue, 1.08A, trust account violations and failure to return funds under 1.15D. But there was not an 804A2, which would have been conviction of a crime.
We hadn't been convicted yet.
In the
Is that what
case,
that-
yeah, but does that answer your question, Mr. Cleveland?
Yes, thank you.
You're welcome.
Any other questions for Mr. Berry? Mr. Krueger, do you have anything further in terms of evidence presentation?
No, ma'am.
All right, Mr. Berry, would you like to close? Or do you have anything further? I should ask that first.
No, I do not. Thank you.
Okay. Would you like to close?
Certainly. Just very briefly, as I stated in response to Mr. Cleveland, the rules specifically allow the commission to share information of any kind, confidential or not, with law enforcement agencies. And that apparently was done in this case. Once that happens, it's out of our hands with, and I wouldn't say that initiated a criminal complaint. I think the Department of Justice then, or whoever handles that, does their own investigation based on the information we've provided and decides whether or not to bring a criminal case. We have in the past given them things and they have not. So I don't know that the people, I can't say whether they knew that what the Department of Justice was going to do with that. So that's just to answer that issue. However, this is a compulsory case based on his conviction, and under 8.05, because he did receive a time of incarceration, the commission has no discretion but must disbar Mr. Krueger. Therefore, we respectfully request that this commission enter an order disbarring Mr. Krueger. Thank you.
Thank you. Mr. Krueger, would you like to make a closing argument?
Yes. So in summary, the reasons that I feel that the disbarment is not appropriate in this case are because of, one, I entered into a final and full agreement with the State Bar of Texas on all matters of the Kilcrease matters. The grievance specifically states all these matters that they are trying to now disbar me for. Whether or not they could have disbarred me if they wanted to proceed with a disbarment act. They could have attempted to disbar me back in June of 2017. They did not. They withheld information from me. I relied on representations by the State Bar of Texas in just the manner with which it was handled. I have issues with, and I feel like there should be some level of accountability on therein. I've already been punished for the same events and crimes that now they are trying to punish me again. The State Bar of Texas and the Chief Disciplinary Counsel is trying to punish me again for the exact same events that they investigated and reached an agreement with me that they were final and resolved. So that's the gist of my argument. The other reason is I understand the compulsory nature of this proceeding, and I understand, I've read those rules and the rules of disciplinary proceedings. And so one of the reasons why I actually wanted to have this hearing as well was because I felt that these items and the actions of the State Bar needed to be put on the record. So if I was disbarred and I petitioned in the future for my license, that it wasn't just treated as an open and shut case as the State Bar finds out an attorney has been convicted in a criminal matter. The State Bar seeks compulsory disbarment and open and shut attorney disbarred. So I wanted this record preserved so that I could possibly use it in the future when I submit for my license in the future, if I am disbarred. Thank you.
Thank you. I'd like to thank both sides for their excellent arguments. You've given us some things to think about. We will take this under advisement. And Mr. Krueger, you are free to leave.
Okay, thank you. Thank you. And thank for the committee and everybody who participated. And Mr. Barry as well. Thank you.
Thank you, sir.
Okay. Unless someone needs a break, you do raise your hand. Otherwise, we'll get to the next one. All right. Mr. Krueger, are you still there?
I'm trying to figure out how to exit. I'm on my phone.
Your audio is really garbled, so I don't know why that is.
I'm just going to turn off my phone and that'll disconnect. Okay, thank you.
Okay, thank you, sir. I'll now call case number 66185 in the matter of James Robert Mason. Mr. Barry, are you ready to proceed for the commission?
I am.
Yeah, okay.
Has Mr. Mason arrived? I don't see him. Ms. Truitt, have you heard anything from Mr. Mason while we were dealing with the Krueger matter?
I have not.
Okay, we'll proceed accordingly then. Mr. Barry, you may proceed.
Thank you. May it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the respondent's professional misconduct and suspension in the state of Illinois. The petition for reciprocal discipline was filed with the board on December the 14th, 2021. An order to show cause was issued by the board on December the 15th, 2021, requiring the respondent to show within 30 days of the order why identical discipline should not be imposed in Texas. Respondent was personally served with petition in order to show cause on December the 21st, 2021 by Matthew Burt, a private process server. Original proof of service was filed with the board on January the 12th, 2022. On June the 14th, 2021, a complaint was entered before the hearing board of the Illinois Attorney Registration and Disciplinary Commission in the matter styled in the matter of James Robert Mason, attorney respondent, number 6331196, commission number 2021 PR 00043, alleging that respondent had engaged in conduct which subjected him to discipline. Specifically, respondent violated Rule 8.4C by the unauthorized use of the law firm's bank account to pay his attorney registration fees, and 8.1A by making a misrepresentation to the administrator of the Attorney Registration and Disciplinary Commission. On October the 14th, 2021, a petition to impose discipline on consent pursuant to the Supreme Court Rule 762B was entered in the disciplinary matter, in which the respondent admitted his misconduct and that requested that the court enter an order suspending respondent from the practice of law in Illinois for 5 months. On November the 16th, 2021, a Supreme Court order was entered in the Supreme Court of Illinois in the matter styled In Re James Robert Mason, MR 030993, Attorney Registration and Disciplinary Commission number 2021 PR 00043, which suspended respondent from the practice of law for 5 months effective December the 7th, 2021, and ordered respondent to reimburse the Client Protection Program Trust Fund for any client protection payments arising from his conduct prior to the termination of his suspension. At this time, I would offer Exhibit 1, which is a certified copy of a set of documents in the Illinois disciplinary matter against James Robert Mason, consisting of the administrator's complaint filed on June 14th, 2021, the petition to impose discipline on consent pursuant to the Supreme Court Rule 762B filed on October the 14th, 2021, and the Supreme Court order entered on November the 16th, 2021, suspending the respondent. Exhibit 2 is the original certificate of Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated January the 18th, 2022, which indicates that respondent is licensed but not currently authorized to practice law in the state of Texas due to an MCLE exemption. Respondent currently resides in Willow Spring, Illinois, and I would ask that the exhibits be admitted at this time.
Thank you. Exhibits 1 and 2 are admitted.
Thank you. At this time, I would ask that the board enter an order of 5-month suspension, active suspension as reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Thank you, Mr. Berry. Are there any questions from the board? All right, thank you. We'll take this under advisement.
Okay, thank you very much.
And Mr. Berry, you are dismissed.
Thank you. You all have a nice day.
Thank you. Board members, why don't we all exit this call and then log back in with the deliberation link. See you in a few minutes.